talk trademark and copyright now. Rapper Cassper Nyovest has filed a lawsuit against Tsonga musician Mayengani for using the hashtag #FillUp to promote his gig. Now, it's led to a debate on whether Nyovest should have gone the legal route here. Some South Africans say that while Nyovest did trademark the term, he did not invent the concept of filling up stadiums, as many artists before him have already done so. Well, yesterday we spoke to Nyovest's attorneys. This morning we have an independent attorney who's going to give us just some ideas to how this should have been handled or could be handled. Abdul Rauf Kamar is from De Beer Attorneys, and he is in our Cape Town studio for us this morning. Abdul Rauf, a very good morning to you, and thanks for your time. Now, let's just talk about, let's just go to that question. Was legal action actually necessary in this case, given also when it comes to Cassper Nyovest registering this term, hashtag #FillUp, that is still in the process. It's not a done deal yet. The paperwork has not been stamped, to put it that way.
Good morning to everybody in the studio, and thanks for having me. Like you rightfully pointed out, at the moment, Cassper and his legal team has gone on the approach that they do in actual fact have legal rights when it comes to the hashtag #FillUp. That is in actual fact incorrect. At the moment, they have filed for the mark in 2016. However, there's no trademark protection in the mark as yet. The mark is currently accepted with conditions, and once a trademark is filed, it takes between 2 to 4 years for that mark to be registered. So at this current moment, there is no legal rights within the mark, and it is merely accepted with conditions. So they cannot take a stance, a legal stance, instituting trademark infringement, because there is no trademark protection in the matter as yet. There is a trademark application, which means that Cassper is an applicant, but is not the proprietor of the mark, and that essentially means that there's no ownership at this moment to that phrase, hashtag #FillUp.
Now, and we've also got Benny saying they fill up Peter Mokaba Stadium. I mean, could there also be, I mean, if it did come down to it and it came to a bit of a tussle, never mind the legal tussle, but the disputing of this, that the wording is different. It's not exactly saying fill up, but he's saying fill up a particular stadium. Could that sort of be, you know, could it come down to the nitty-gritty of that he doesn't actually have a case, Cassper Nyovest?
Strictly speaking, that it will be an argument that the other side will definitely make, but however, one has to look at it in a very logical aspect, and the predominant part that Benny was using was hashtag #FillUp. So the association is on the predominant elements, which is that first part, hashtag #FillUp. So it's going to be a decision in the court's eye whether they view hashtag #FillUp as a predominant part, and in my view, that is the predominant part, because, I mean, if you see it and you view it side by side, if you look at it automatically, it both says hashtag #FillUp. So from my opinion, the inclusion of the other words does not make that much of a difference to Benny and his case.
All right, Abdul Rauf, I suppose the question is here, while we still navigate sort of how the workings of social media and things like hashtags, I mean, can someone claim ignorance to say, listen, I didn't realize that I couldn't use it. It's out there in the public domain, and hashtags I use. I saw it on Twitter and thought that I could use it.
So ignorance of the law is no excuse, and even though at the moment Cassper them don't have trademark protection in that matter, they can revert back to the common law, and the common law merely says that if I can show that I have a reputation in this mark and that I've been using this mark for a substantial amount of time and consumers associate that mark with me, I do have a case. It's only the only problem is to show that reputation. It's much more difficult, whereas if I had a trademark registration, it's much more easy, because with the trademark registration, all that I need to show is a piece of paper. This is my registration. Wherever I take the common law approach, I actually need to go as far as saying, listen, I have a reputation in this mark and I need to prove this reputation. One needs to also keep in mind that with trademark protection, even though Cassper doesn't have that registration rights at this current moment, that mark was filed in 2016, and should he get that registration rights, whether it's in 2 to 4 years from today, those marks are going to backdate to 2016, and he will eventually, if that mark is given to him, he will have trademark protection, and he can take legal action based on the Trademarks Act.
Okay, Abdul Rauf, very quickly for us, in your independent view, what is the best way to sort this dispute out?
the best way is always to make a settlement negotiation. Obviously, nobody wants to go to court. At the one end, you have Cassper that they are fuming on their side. On the other side, Benny has the backup of the EFF. Julius Malema, them all came to his defense saying that they strongly condemning Cassper's approach to this, because if one looks at it, the term fill up, it's a common English term. Everybody uses it. So if Cassper then goes further with this mark, it's in all probability going to be opposed when it gets to the publication stages. So it would be best to obviously try for the parties to come to a settlement negotiation, because if this is going to enter into the litigation arena, it's going to be very, very costly, and in my opinion, it's totally unnecessary.
All right, thanks very much for that. Let's hope the interested parties have been listening. Abdul Rauf Kamar from De Beer Attorneys in